evening, friends. Welcome to today's session on another important topic relating to polity part of the general studies paper, that is union and its territory. So far we have studied about the salient features of the Constitution, the making of the Constitution and preamble. Now this is the first part of the Constitution. In fact, there has been a detailed session on this which has been recorded and is available on YouTube. That's why I am just taking it from the point of view of polity paper, which will serve your purpose for the general studies paper 4 in the mains examination, and will help you in answering the questions which are generally asked in the Prelims paper, in the general studies part. See, the basic feature of the Constitution is not only the type of governance it is providing, but also more importantly, what will be the territorial structure of the nation. So, Constitution gives us a territorial framework within which the whole, governance is to be carried out. We cannot go across our boundaries. We cannot govern other nations. We are ourselves a sovereign nation having our own territory. But that does not mean that we can give away our territory to any other nation or any other entity. So how it has emerged, how we got the name Union of India, what does it mean, what is its territorial structure, and how the Parliament has been given certain powers, certain authority to carry out any changes in that territory with respect to external additions, reorganizations of the boundaries within the framework, within the total framework of the nation into its units, that is called states and union territories. So today's session will be primarily focused on all these issues. Now, what is going to be the important part here is that we are not getting into in-depth details based on the decided case laws as is required in the law optional paper in the mains examination. For that, I will be sending you the link. Those who have already seen on the YouTube, well and good. I would request you to, after this session is over, that you should again see that and with all concentration so that you can prepare for your law optional paper also on this particular topic. It is not that we leave it to you to, watch that session once again and we will not be doing anything more than that. What we will be doing subsequently when we go through the law optional paper, the part relating to this particular topic is that we will be answering those questions which have been asked in the previous years, plus some more model questions. So that will be our exercise at that time when we take up one full session will be on that, exclusively for answer writing. What we are going to do today is prepare this particular topic for our polity part of the general studies. And when you watch the same video on the YouTube, or if you ask for a link, we can send you a separate link for that, and you watch that, that will be giving you the contents on this particular subject. Plus, you will be getting the notes, those who have not yet got the notes so far on this topic, so that the content part will be over. So when we come to the law optional paper studies, we will be attempting the questions and we will learn the art of writing the answers. So let us begin with our session today. Union and its territory. This part is actually part 1 of the Constitution. This is the first part. Now, what happens when a new statute comes? It will define, other than the preamble and the statement of objects, etc. The first thing, it will give you a title. So, when it comes to Constitution, I am talking of the general statute. The first section in any statute is generally giving the title of that particular statute. Since this is the Constitution of India, the supreme law of the land, the fundamental law of the land, what it is going to tell us after the preamble. So, the first part deals with what will be the name of the nation, number 1, what will be its structure in terms of territory. That is why I say union and its territory. So, let us start with the first part, that is the name. Now, name itself indicates what kind of polity we are going to have. The name is reflecting too many meanings. Let us understand all those meanings in the simplest terms. It is called Union of States. So, what Article 1 describes in terms of text is India, that is Bharat, is a union of states rather than a federation of states. So, what does it say? That it doesn't say it is a federation of states, it says union of states. Now, let us come to the first issue. First is between India and Bharat. What will be the name of the nation? Now, in the Constituent Assembly, there was a debate on that as to what should be the name of our nation, the independent nation. One section said it should be India, the other section said it should be Bharat. So finally it was decided that both the names should be incorporated. So that is why it is called India, that is Bharat. So this is the first thing which we have to learn and make a note of it. Now it is describing India, that is Bharat, not as a federation of states, but as a union of states, though it has got a federal structure. How? We'll say. So this provision first deals with what? The name of our country and the type of polity. Now, name we have seen here. Now we will talk about the polity, and the polity will be, it will be a union and not federation. In spite of what? in spite of being having a federal structure. Now, what is this federal structure and what is the federation? Let us try to understand this. Forget about union for the time being. Let us say, what is federation? What is federal structure? In a federal structure, there are different units. Those units join together to form a nation, a country. When these units, they join, I am not telling you right now as to what will be the system of their joining, what will be the process of their joining. It will come. But for the time being, try to understand that there are different territorial units which come together and form a nation, a country. And that country or that nation, after their joining, becomes what? A federation. Okay? So here also, if you see in the case of India, in our country, we have different states. How many? We have 28 states and 8 union territories. I'll explain to you what is the difference between the two. Now, just take them as units. 28 states, 8 union territories. These are the units which have joined together, come together, formed a single nation that is called India, that is Bharat, and have got into what? A federation. That is why it has got a federal structure. Now we come to the union part of it. Okay? Now, Dr. Bhimrao Ambedkar, if you remember, the chairman of the drafting committee in the Constituent Assembly, he says that union of states is preferred to federation of states for primarily 2 reasons. Okay, in the first slide we saw we have not gone for the name Federation of States, but we have gone for the name Union of States. What are these 2 reasons? Very, very important. The Indian Federation is not the result of an agreement. This is very important. Must remember this. That the states who are part of India have come together, joined together to form the union or the federation, we can say, not as a result of an agreement. There was not an agreement between the federal government and the states. Now, whereas in the case of American Federation, from where we got the system of federation, federal structure, there it is a result of an agreement. This is the difference. Though we got the concept of federation from there, but we adopted it in a different manner, through a different process. And that process did not involve any kind of an agreement between the states or between the states and the federal government or the union government. So, the Federation of India is different from American Federation on this point. This is very important. Now, the second important part is the states, once they have joined the federation, cannot get away. This is only a one-way process. The states have no right to secede. This is another important point. So these 2 points we have to remember. Why Indian Federation is a union. So federation is a union because it is indestructible. Now, what is indestructible and how does it function? We will see now. The country is an integral whole. That means it is one single unit, one union. Once the units have merged into that, they are now integral part of the union. Now they are divided into different states. You may say that once they have merged into the union, they should lose their identity. No, they have not lost their individual identity either. What they have now been called are different states. And why they are still called states? Only for the convenience of administration, because we have 28 states and 8 union territories. It's a huge country. So if it is a single unit, it will be very difficult to administer. So for the sake of convenience of the administration, the units have been allowed to be states. Now, what is the important feature of their existence as states is the separation of powers, the division of powers. What power states will have to administer certain subjects exclusively by them or concurrently with the union. That we will see, but just basically remember, for the sake of convenience of administration, these states have been allowed to retain certain kind of autonomy. Certain, it's a very limited autonomy. Now, according to Article 1, this is the first article, the territory of India can be classified into 3 categories. The first category is the territories of the states. Second category is the union territories. And third category has been left open. What is that open type? It is the territories that may be acquired by the government of India at any time. So this is a open-ended type. First 2 are the definite ones. Third is left open to the choice of the government. So their names appear in where? First schedule. The names of the states and union territories and their territorial extent are mentioned in first schedule. Right? So you can link Article 1 with first schedule. Now, as I said, there are at present 28 states, 8 union territories. We will see, how different states have been reorganized, new states have joined, their names have been changed in the later part of our session. And how they were, given, how these changes were carried out. There have been some special provisions under Part 21 of the Constitution which are applicable to only some states like Maharashtra, Gujarat, Nagaland, Assam, etc. Okay, these are the provisions which are dealing with the states. Now, 5th and 6th schedules, administration of the scheduled areas and the tribal areas within the states, because these are the special areas which need special attention. So, as far as the territory of India is concerned, the overall system of, having a territory in India is primarily based on these three types. First two are fixed ones, third is left open, left to the Government of India to acquire. Now, acquiring a territory, I have already told, is the sovereign function of any state, any nation. So, where these names and territories appear? In the first schedule, some special provisions for some special states, and fifth and sixth schedules regarding the scheduled areas and the tribal areas within the states. Now, which one is a wider concept out of these two? Territory of India and Union of India. Now, we'll come to this. Union of India consists of the states. States who have joined together to form India. They are the union. Now, territory is a wider concept. How? Because of the third factor which we have seen, which is a open-ended one. The first two states plus UTs, they form the static part. But the next part, that is acquisition of new areas, acquisition of new territories, which is the prerogative of a sovereign nation, comes here. So that is a to be acquired at any point of time. So that is why the territory is a bigger concept and Union of India is a smaller concept as compared to that. So it has got a wider connotation, and that wider connotation is because of its open-endedness. Now, here is the difference. It includes only states. It includes states, UTs, territories that may be acquired in future. Members of the federal system and share a distribution of power with the center. That's what I said. How the powers are distributed through three lists. What are those three lists? Union list, state list, and the concurrent list. What does it mean? As far as the powers within the union list, the subjects which are listed in union list, the union government only has powers to make laws. The state list subjects, where the states legislature have got the power to make laws. And in the case of concurrent list, both union and the states have the power to make laws. Now, as far as UTs are concerned, they are directly administered by the central government. Okay? So, this is what the overall framework is there, where Union of India and Territory of India, we have given a matrix on that. So, now we have seen in the third part that being a sovereign state, India can acquire foreign territories according to the modes recognized by international law. Now, international law has got certain modes. They have listed out certain modes through which one nation can acquire a territory of belonging to either another nation or those territories which have not been so far acquired by anyone. There are no claimants. Okay, so how they are done? One is the cession, following the treaty. What do you mean by cession? That means one nation voluntarily gives its territory to another nation. That means without any coercion, without any force, they themselves come forward and say, okay, this much part you can take and it will become a part of your nation now. So how they do this? They do it by way of a treaty. Either they do it with by way of a bilateral treaty or purchase. There may be, they may be selling their territory to another nation by way of gift, by way of lease. Lease is like, for a certain period of time, it's like you are renting out. Or after, you do not give the right of ownership, but you give the right of possession for a certain period of time on certain conditions. Or plebiscite. Plebiscite means by way of general voting, option given to the people who are living in that territory. If they choose, they can go to another nation. So these are some of the recognized modes where the cession is allowed by international law or recognized by international law. Second is occupation. As I said, there are certain territories, maybe some island here and there, which has not been occupied so far, which has not been inhabited by any person or any nation or claimed ownership by any nation, and it remains unoccupied by any recognized ruler. That means there is no recognized ruler who is claiming a right of ownership or even possession over that particular territory. So, in that case, a nation can go and occupy that. And third is by way of conquest, that you win it. Okay? Or subjugation. What is the difference between the two? In the case of conquest, you win over. Okay? You go, you fight with the people who are occupying that and win over. So you conquer them. And subjugation is that they surrender it to you. They themselves surrender it to you. But that is primarily due to some violent means, by way of war, by way of aggression, or any other mode of, forceful occupation. So either the one nation will go and conquer that, or the nation which is already owning that can subjugate to the other nation. Now we come to Article 2. Article 1 deals primarily with the overall territory of the country, its units, its structure, whether it is a union or a federation, and how to acquire and get those new territories into their own territory. They form part of their own. Article 2, now what if suppose we have acquired a new territory? How to admit it into Union of India? Because simply it cannot come and join. It has to be joined formally and made an integral part of the country. So it can be admitted into Union of India. Who has got that power? That power lies with the Parliament. Or establish new states. on certain conditions. So these two powers have been given to the Parliament. Admit new territories and establish new states. Article 2 grants two powers to the Parliament: the power to admit and the power to establish new states, establishment of states which were not in existence before. Whereas in the case of power to admit into Union of India new states is the admission of the states which are already in existence. The example is Sikkim. Now Sikkim was a state which was already in existence. It was admitted into Indian Union. How? Through a law passed by the Parliament. Second is creation of a new state. You create a new state and that state is also created by through a law passed by the Parliament. We'll see the entire list how this whole process has evolved over a period of time. Now, Article 3 has got a different feature. It has a feature of creating changes in the existing states. Here it is the new states. Article 2 deals with the admission or establishment of new states. Article 3 talks about the changes in the existing states. How it is done, we'll further study. Now, it is external readjustment, whereas it is internal readjustment, inter se, of the territories. What do we mean by that? Now, suppose we take, this is the country, there is a state which was earlier not a part. So what happens after its merger, after its admission, now our boundary will be like this. So one external state, there is an external readjustment of the boundary because that state has now become a part of the union. Whereas in this case, in the case of Article 3, suppose this is our country, there are different units. Now what happens, since this is a larger state, it is divided into two. But the overall boundary of the country remains the same. It is only the internal readjustment. Right? So, you know the difference? When a new state joins, the external readjustment has to be made, and when there is an internal readjustment within the units, then it is called the internal readjustment. Inter se the territories. The total territory remains the same. Here there is a change in the total extent of the territory. Now we come to the Parliament's power to reorganize the states. We have seen this reorganization of the states where? In Article 3. Here. So Article 3, what does it do? It authorizes the Parliament to form a new state. How? By these three means: separation of territory from any state. A part of that is separated from one state and a new state is created. By uniting two or more states, or parts of states by uniting any territory to a part of any other state. That means, suppose there is a state, it is a new state is carved out of it. This is the new state. Earlier, this was the old state. prior to reorganization. So, a new state has been created. Or if there are two states, they are joined together and made a maybe two or more states, they are joined together and formed into a new state. Or parts of some states, different states, not the whole state, but the parts, they are readjusted. It's a huge power of the parliament. By making a simple ordinary law, they can do all this. How that process is, we will study now. Now they can increase the area of any state. They can diminish the area of any state, alter the boundaries of any state, and alter the name of any state. We have seen this, like Uttar Pradesh was divided into Uttar Pradesh and Uttaranchal. Later on, Uttaranchal was changed to Uttarakhand. So, similarly, recently we have seen what? Andhra Pradesh being divided into Andhra Pradesh and a new state called Telangana. A part of it is taken away. So, a new state is formed. It is called reorganization of the states. Now, it lays down, Article 3 lays down two conditions in this regard, that means with respect to reorganization. Now, a bill can be, as I said earlier, how the parliament will do this reorganization is through by way of passing a law. Okay, now that is the power with the parliament. But if a bill, I have already explained how a bill is passed and made into a law or act. So, before it becomes an act, before it is passed by the parliament, when a bill is to be introduced, it must have the prior recommendation of the President of India. This is very important. This is one of the conditions for that. Now, before this recommendation, before recommending the bill, the President will send it to the state legislature concerned for expressing its views. This is very important, only expressing its views within a specified period. Power of parliament to form new states includes the power to form a new state or union territory by uniting a part of any state or union territory to any other state or union territory. This is a part of reorganization which we have already seen. What is more important is these two parts, these two conditions. That the bill before being introduced, before it is introduced in the parliament, must have a recommendation of the President of India, and the President will send it to the concerned state legislature for their views, not their consent. We'll see now. Now, the President or the Parliament is not bound by the views. Whatever the state legislatures may say, they may consider or they may not consider. President or the Parliament may consider or may not consider. Okay, it is only sent for their views. May either accept, reject them, even if the views are received in time. See, we have seen it has to be within a specified time period. Suppose the views have been received by the President in time, within that stipulated time, still it can be accepted or rejected. Not necessary to make a fresh reference. That means once the views have been received or not received, no fresh reference will be made to the state legislature. Okay? Or any time any amendment is carried out to the bill. Suppose the bill has been introduced and an amendment is also suggested that an amendment should be made to the bill, the provisions of the bill. And at that time, no need to make any fresh reference. In case of a union territory, no reference. Why? Because union territories come directly under the control of the central government. So there is no question of referring them to any state legislature. Now, this is important. No need of consent. It is not necessary that the state concerned should give their consent. It is a process of what? At the most, consultation. So, it can be consultation, but it cannot be consent. Please remember this, make a note of it. Now, Parliament can redraw the political map of India. This much of the power is there with the Parliament, according to its own will. Hence, the territorial integrity or continued existence of any state is not guaranteed by the Constitution. This is what I wanted to tell you by indestructible unit. That means the unit which has been created, the Union of India, is indestructible. But the states are destructible. That means the union cannot be destroyed or cannot be altered or changed, but states can be. So, this is the great feature of Indian Federation, Indian federal system. This is how we have adopted the federal system to our own conditions. We have picked up the idea, concept from other federations, but we have adopted it as it suited us. So, it is indestructible union. That means union cannot be destroyed, but states can be. So, states are destructible. Whereas, from where we got this idea of federal structure? USA. But in USA, both indestructible union of indestructible states. That means the states must give their consent for any changes. Whereas in the case of India, we don't need any consent. Only a process of consultation is there to ask for their views, and which are not even binding. Okay, so this is the difference between the federation of the federal government, American federal government, and our Indian Federation. So, Article 4, we come to the last article of this part, which says that the laws made under Article 2 and Article 3. Article 2 is for new states and Article 3 is for reorganization and renaming of the states, are not to be considered as amendments of the Constitution under Article 368. This is important. There are case laws on that. We will see in the next slide. But just remember, they are not laws which are made to create or admit new states, and laws made by the Parliament for restructuring and renaming of the states are not to be considered as amendment to the Constitution. They have to be treated as what? As ordinary laws because they are passed by simple majority and are ordinary through ordinary legislature procedure. Now, we come to an important, discussion on power to cede Indian territory to a foreign country. You must remember this thing. The Supreme Court has also held that the power of Parliament to diminish the area of a state under Article 3 does not cover cession of Indian territory. So, Indian Parliament has no powers to cede Indian territory to any other nation or entity. So, Indian territory can be ceded to a foreign state. That means if they are following the process of what? The ordinary laws under Article 2 or 3, they cannot cede the territory. But if because of any international treaty, some reorganization, readjustment of boundaries is required, in that case, the only way any part of Indian Union can be given or readjusted is by way of amendment, amending the constitution. So, where the amendment will be done? To the first schedule. Why first schedule? Because the first schedule has got the names and the extent of territories of each of the states and the union territories. So, if there has to be any changes in the territory, that will require amendment. Otherwise, it will be any other thing, admission of new states or reorganization of the new states. Article 2 or 3 requires only passing of an ordinary law. The important case here is the Berubari Union case of 1960. This was a reference case with respect to adjustment of boundary, some territorial agreement. Further, Supreme Court ruled that the settlement of a boundary dispute between India and another country does not require a constitutional amendment. It can be done by a executive action as long as it does not involve cession. That means if there is a settlement of boundary dispute between India and any other country, provided there is no cession of the Indian territory to a foreign country, in that case, only an ordinary law will be sufficient. It will suffice. We need not go for a constitutional amendment. The constitutional amendment is required only in case of if we have to cede any territory to any other nation. Now we come to an important, because this is important from point of view of examination now, that 100th constitutional amendment in 2015. This was exchange of territories between India and Bangladesh, a very, very long pending issue. Okay, so in that case, India transferred 111 enclaves to Bangladesh. Bangladesh transferred 51 enclaves to India. So it was a kind of, reorganization of the or settlement of a border dispute, boundary dispute. And mind you, just now we have seen it could be done by way of a constitutional amendment, and here is that constitutional amendment. Okay, so transfer of adverse possessions and demarcation of a 6.1 kilometer undemarcated border stretch. So there was some undemarcated, which were not marked. There was no demarcation of the boundary. So about a stretch of 6.1 kilometer. These facts, please note down. This will help you in your Polity GS paper. modified territories of 4 states. So from where this modification, demarcation was done? Assam, West Bengal, Meghalaya and Tripura in the first schedule. So there was a amendment to the first schedule. And that amendment was this one, 100th amendment. So what was the background? This is not required for the purpose of your law optional, may not require. I'm not saying not required, but may not required, but certainly required for your polity paper. India and Bangladesh land boundary is about 4,096 kilometers. So, Radcliffe Award of 1947, which demarcated the boundaries between India and Pakistan, because at that time, Bangladesh was known as East Pakistan. So, it related to boundary demarcation. Bagge Award of 1950 to resolve the disputes, but not resolved. There was an agreement between Nehru and Noon in 1958, still remained unresolved. Barabari Union case, 9th Amendment Act, but could not be notified. So there were further agreements of 1974 and 2011, but still that boundary settlement was not coming through. It finally came through this settlement in 2015. Now we see the evolution of states and union territories, how they have evolved. One was the integration of princely states. See, what happened was, we have already studied during the making of the constitution that we had the provinces and we had the princely states. Now, these provinces were directly controlled or administered by British, and these were administered by their kings or the Maharajas. So, these two were merged. How? Provinces were directly merged into the union, princely states by way of an instrument of accession. So, whosoever signed that instrument, they decided to either join India. How they were integrated? Either they joined India or Pakistan, or to remain independent. So they gave this Indian Independence Act of 1947 gave 3 options to these. So then the other states were, we will see these 2 commissions, how they worked and on what conditions in the next slides. But new states and union territories which were created after 1956. So this is how the evolution of states occurred. These 2 just keep on hold for some time till we explain them in more details. So as far as princely states were concerned, they had to opt either of these 3 options. So out of 552 princely states, 549 joined India, and the remaining 3, Hyderabad, Junagadh and Kashmir, refused to join India initially. So how they ultimately got integrated into India was Hyderabad by means of a police action, Junagadh by means of a referendum, and Kashmir by instrument of accession. Okay. In 1950, they were having 4 classifications of the states. Part A, Part B, Part C, and Part D. Andaman Nicobar was kept as the solitary Part D territory. This was later on abolished. We will see how. Now we come to those two commissions which I mentioned in one committee. What happened when the princely states joined the Indian Union? They were having different cultural and linguistic, characteristics, features. Now, those features, they just joined by signing the instrument of accession, or otherwise in the case of Hyderabad and Junagadh, purely an ad hoc arrangement. They said, okay, we are joining, but later on, the modalities about their size, their integration with other territories will be decided. And what will be the basis of that? Basis of their joining or getting integrated into the union territory, into the territory of India, and with other states, those criteria, for determining those criteria, one Dar Commission was formed in June 1948. So the basic demand was that you reorganize the states on linguistic basis. That is, on the basis of the language spoken by the people there. So a linguistic provinces commission under the chairmanship of S.K. Dhar was appointed. That is why it is called Dhar Commission. What was the recommendation of that commission? The reorganization of the states on the basis of administrative convenience and not on linguistic factors. So they rejected the demand for reorganization on the basis of linguistic language. They said no, administrative convenience should be the criteria. So after this, a JVP committee was formed in December 1948. Why it is called JVP? Because there were three members, Jawaharlal Nehru, Vallabhbhai Patel, and Pattabhi Sitaramaiah. So these three, that is what it is called JVP committee. Now, what this committee, this also rejected the language as the basis for reorganization of the states. Now, that was in 1948. But in 1953, the first linguistic state of Andhra was created. With this, again the demand for reorganization on linguistic basis was raised. So, a Fazal Ali Commission was constituted, appointed in December 1953 after the creation of Andhra state. This was a three-member States Reorganization Commission. So, who was the chairman? Chairman was Fazal Ali, to re-examine the whole question of reorganization on the basis of language, that is on linguistic basis, which was earlier rejected by Dhar Commission and by the JVP committee. So the other two members were K.M. Panikkar and H.N. Kunzru. This commission broadly accepted the language as the basis of reorganization of states, but it rejected the theory of one language, one state. So for each language, each state to be reorganized, this theory was rejected by the Fazal Ali Commission, but they said reorganization of the states could be done on linguistic basis. So they organized four major factors. What were the? Four major factors: preservation and strengthening of unity and security of the country, linguistic and cultural homogeneity, financial, economic and administrative considerations, planning and promotion of the welfare of the people in each state as well as of the nation as a whole. So these were the guiding factors. Now, what do you mean by homogeneity? Linguistic and cultural homogeneity. That means there should be a homogeneous mix of the language and culture. It should not be a heterogeneous society. So these were the four bases, and being a welfare state, welfare of the people and of the state and as a nation as a whole. So these were the four criteria laid down by them. So what I said, there were Part A, Part B, Part C and Part D classification. This was abolished. It suggested, the Fazal Ali Commission suggested this. So Government of India States Reorganization Act was there 1956 and 7th Constitutional Amendment Act 1956. 14 states and 6 union territories were then created. This was the beginning of reorganization. Now we will see the whole process. So in the first stroke, in 1960, Maharashtra and Gujarat. New states and union territories created after 1956. So, in 1956, as we see, there is a States Reorganization Act of 1956 and 7th Constitutional Amendment, where 14 states and 6 UTs were created. Now we come to the scenario after 1956. So, in 1960, Maharashtra and Gujarat. Now, Dadra and Nagar Haveli were under the Portuguese control. So, they were liberated in 1954 and under the 10th Constitutional Amendment Act of 1961, they were formed into union territories. Goa, Daman and Diu, again liberated from Portuguese by police action in 1961. 12th Constitutional Amendment in 1962. And in 1987, Goa was given the statehood, whereas Daman and Diu remained the union territories. Very important issue, because earlier they were together under the Portuguese rule, liberated, and then they were single unit divided into statehood to Goa, and Daman and Diu remained UTs. Earlier they were UTs. Puducherry, earlier it was called Pondicherry. It was under French rule. It was liberated in 1954, and through 14th Constitutional Amendment Act of 1962, it was made a union territory. Nagaland, in 1963, to satisfy the hostile Nagas, this is a new state created. Haryana, Chandigarh and Himachal Pradesh. 1966, Punjab was, divided into Haryana. Chandigarh was made a UT. So Shah Commission gave this recommendation. Punjab and Haryana as states, and Himachal Pradesh as states, and Chandigarh as a unitary. So these three states were created in 1966, and Chandigarh was created as a UT. 71, Himachal Pradesh was given a statehood. Earlier it was a UT in 1966. So 1971, it was given the statehood. Chandigarh remained the UT. So we come to Manipur, Tripura and Meghalaya. Through 22nd Constitutional Amendment 1969, Meghalaya as an autonomous state within the state of Assam. First, it was the part of Assam. Then, 1972, Manipur, Tripura and Meghalaya were given statehood. Mizoram and Arunachal Pradesh were made union territories in 1972. Sikkim, through 35th Constitutional Amendment 1974, it was made associate state. A new Article 2A and 10th schedule was created for Sikkim because Sikkim was a foreign territory earlier. So, through 36th Amendment in 75, it was made a full-fledged state from an associate state. Okay? So, it amended first and fourth schedule. Repealed. Now, I have told you about the first schedule. First schedule is about the names and territories of the states and union territory. Fourth schedule is about the number of parliamentary and legislature seats from there. Okay, so that is why, because of the change, a new territory was added, so it required amendment to fourth schedule also. But it repealed 2A, Article 2A and the 10th schedule. So Mizoram, Arunachal Pradesh and Goa made states in 1987. Chhattisgarh, Uttarakhand and Jharkhand in 2000. Now, you know, Chhattisgarh was earlier part of MP. Uttarakhand was part of Uttar Pradesh and Jharkhand was part of Bihar. They were separated, some territory was taken out and was named. Now, Uttarakhand was earlier Uttaranchal. Later on, it was changed to Uttarakhand. Telangana from Andhra Pradesh in 2014. Jammu and Kashmir and Ladakh, last year, we have seen the constitution application to J&K order. It was an order. Jammu and Kashmir Reorganization Act was passed in of 2019 and Jammu and Kashmir and Ladakh were made UTs. Similarly, Dadra and Nagar Haveli and Daman and Diu, they were made single UT by way of a constitutional amendment. And that amendment is your it is through an act, the Dadra and Nagar Haveli, Daman and Diu Merger of Union Territories Act. So, it was a merger and came into effect in January 2020. So, if we see the change of names, earlier the United Provinces was named as Uttar Pradesh in 1950. Madras was renamed as Tamil Nadu in 1969. Mysore was named Karnataka 73. Lakshadweep, Minicoy and Amini Islands were made as Lakshadweep in 1973. UT of Delhi was named as National Capital Territory of Delhi. It is called NCT. NCT of Delhi. In 1992, Uttaranchal to Uttarakhand 2006, Pondicherry to Puducherry 2006, Odisha to Odisha in 2011. So, friends, with this we come to an end of this session. Primarily, as I said, this topic has been taken up in this session through keeping in mind the requirement of the polity syllabus for the general studies part. But this is also a first step towards understanding the more complex issues involved in the part 1, which has been covered extensively in our video, which is already there on the YouTube, and the link you will be getting very shortly, another 5-10 minutes from now. Go through today's session and that video. You have any questions, you have any queries, you can send them to me through email. I will answer that, and there will be a separate full 2-hour session when we take up the law optional syllabus. At that time, we will be attempting to answer the questions which have been previously asked, and also some model questions which I will be drafting for you. So if you have any questions, any doubts, or any clarifications to ask me, please go ahead. And let me also remind all of you that only few of you are sending your notes. I expect that all of you please spend some time, because I tell you, civil services requires a lot of hard work and lot of time and devotion on part of the aspirants. So you cannot be, you have to manage your time accordingly. So whatever has been discussed in the session, I have already been telling you to make the notes simultaneously and also refer to these videos. Now this session is being recorded and you will have access to this. You can send a request, you will have access to these videos anytime you feel like, till your mains examination next year. So there's plenty of time, but my request is repeatedly go through these discussions and sessions through these videos and also through other recorded videos, and then club them together, write your notes for polity separately, which has been discussed here, and for your law optional separately. And then you can send them for me for my feedback on that. Okay, so now house is open for discussion. Hello, yes.
Hello, sir. Go here.
Yeah, please.
Why do you need a 10th constitutional amendment or 12th constitutional amendment?
Pardon?
Why have we needed a 10th or 12th constitutional amendment? Since Article 4.
Why we needed a constitutional amendment? Hello, yeah, please.
10th or 12th constitutional amendment.
10th and 12th constitutional amendment.
Yes.
So I'll just go back and see what is there in the 10th and 12th constitutional amendment. Yeah. They were liberated from Portuguese and they were added to this. See, they were under a foreign rule. Okay. Portuguese rule, both in the case of Dadra and Nagar Haveli and Goa and Daman Diu. So in these two cases, when they have to be admitted, there has to be a need for what? Amendment of the first schedule. That is why amendment was required. A foreign territory was being, though it was Indian territory, but under a foreign control. So it had to be admitted through a constitutional amendment.
But Article 4 tells actions contained under Article 2 and 3 has to be done through a simple majority.
That's what I'm saying. 2 and 3. 2 is for creation of a new state. 3 is for the reorganization of the states. It doesn't come under the 2. It is a typical situation where though an Indian territory but was under a foreign control. So it had to be admitted by way of a constitutional amendment of under 368.
Okay, thank you.
Yeah, welcome. Yes, please. Yes, please go ahead.
Good evening, sir.
Good evening. Please go ahead.
Sir, can you repeat once more the meaning of the result of an agreement?
Result of agreement for in the case of federation.
Yes, sir.
Okay. We'll go back to our first slide, right? Yeah. Here. Result of an agreement. Now, as you see in the case of America, USA, which is a typical case of a federal structure, now in that case, the units, they join the federation through an agreement. That's what I'm saying. They will come forward that and say, we want to join the United States of America. In that case, they will sign an agreement with the federal government. Or if it is between two or more states, they have to sign an agreement. Whereas in the case of India, Indian Union, it was not a creation of any agreement. The states simply joined the union. States at that time were what? They were the provinces. Yeah, I think I mentioned somewhere, provinces. Anyway, I'll go back to this. Okay, so here I said they were provinces. So among the states, there was no need for any agreement, not the result of an agreement, as in the case of American Federation. So Indian states, they simply joined by way of the Indian Independence Act, whereas the princely states, they had to sign an agreement of accession, instrument of accession, not an agreement. They had to sign an instrument of accession. So Indian Federation is not result of any agreement, whereas the other, federation, that is the Federation of United States, is a result of an agreement. Is it clear or should I further simplify it?
It's clear.
Thank you.
So instruments, what does an instrument mean, sir?
Yeah, instrument is a paper, a declaration. Okay, don't get it's a technical word, it's a legal term, instrument of accession. Accession means they accede themselves to the union. But instrument is a paper, it's a declaration which they had to sign. So it was an instrument of accession through which they princely states, they became the part of the Union of India.
Thank you.
Welcome. Yeah. So friends, if there are no further questions, we will meet tomorrow with a new topic and on the same pattern. Okay? This pattern will continue till your polity part is also covered. This is what I am saying. What we are trying to give you is an advantage over others. You will not get this kind of pattern in any institute, anywhere. Because though you are law optional students, we are preparing you for the law optional paper of your mains examination. But at the same time, we want that your basics for the polity part of the general studies should also be strong, so that you are well prepared for that part also. So we are giving you both the advantages. This is my purpose of making the basics clear. Now, having made the basics clear to you, it will be easier for you to understand the complex parts of the law optional topics relating to constitution. Now, I think your basics are getting cleared in the most simplest form. Once that is done, your polity part is automatically taken care of. And at the same time, when we take up the complex parts, the real, hardcore topics from the syllabus for law optional paper, you will be at ease to understand them and to answer the questions in a better manner as compared to any other student. So this is the purpose. I am not just simply wasting your time on this. I am strengthening your foundation and also creating another building, additional part of your building of polity paper. Is it okay with you? Or should we change the pattern? Please react to this. Thank you so much. Thank you very much. And if you have any observation, you can always write to me. My purpose is to make you succeed in the examination. And for that, if we have to go little here and there to cover other aspects also, along with our main core law optional paper subject, I am ready to do that. And that's what I am doing here now. Okay? So thank you very much, friends. See you tomorrow. Have a nice evening and good night. Thank you.
For more videos, subscribe to N BY IAS and press the bell icon to never miss an update.